next week. Um, for those of you who don't know much about DLZ's ADA compliance expertise and experience, we have been doing this type of work for well over 10 years now, specifically related to ADA compliance, assisting our clients who our very first client approached us because they had a complaint filed against them by a local disability advocacy group. And the advocacy group noted that the city did not have an ADA transition plan. So our client asked if we would be able to assist. We obviously looked into what went into a compliance investigation and development of a transition plan and move forward with that, and we're able to help them out. So since that time, we have done a number of different projects, including transition plans and self-evaluations for Title II clients in numerous states. Currently, most of the work I'm doing is in the state of Tennessee, but I have a significant amount of work also in Ohio, Indiana, and Michigan for various clients. And in addition to Title II agencies, we have also done some Title III investigations for hotels and zoos and fast food restaurants and those types of facilities as well. So as I have stated previously, and if you have not already heard as a new attendee, we will be utilizing both the chat window as well as the Q&A window. So if you are not able to both hear and see the presentation at the current time, please notify us on one of those two options as we move forward. So with that, let's move forward with our presentation. Today, we have a number of objectives that we're going to try to present over the next hour or so, hour and a half with questions. So again, feel free to pose those questions as we go through and let us know if there's something that you want to address in a particular slide, and I'll try to make note of that as I go through. But one of the things that we want to discuss is why this topic is particularly relevant now in the state of Ohio. There's been some recent changes that ODOT has implemented and are encouraging LPAs, local public agencies like counties, cities, and towns to move forward with ADA compliance. We'll talk very briefly about the ADA requirements for local governments and go into a little bit of detail about what the ADA is, but that's really boring information. But the relevant components of ADA is certainly important for everyone to have a good basic understanding of. We will cover the requirements for both the ADA self-evaluation as well as the ADA transition plan. I will at the end provide you with a couple of websites that are excellent sources of information from the federal side. But I do want to note that in an hour, hour and a half, it's going to be very difficult to go into a great level of detail. So if you are looking to try to get additional information about how you can actually do your self-evaluation and transition plan, that's really something that will take a significant amount more time. And realizing that we will be hosting a number of half-day seminars in our Columbus, Ohio office that will be approximately 4 hours long. And if you are interested, I would certainly urge you to continue to monitor your email for invitations to register for one of those 4 dates and times that we will be providing that level of detail to get you much more in depth with what are the requirements. But today we will cover a lot of these requirements in enough detail to let you know what you need to do, and also let you know some of the things that you may not be aware of and the things that we see communities that try to do it on their own without guidance. The most common errors that many of them do make. As I have stated a couple of different times, please post questions as you have them. So as questions come up, I will be able to respond to those, and would love to be able to have the questions asked about a particular slide, and hopefully I don't go past it. I do want to note that ADA is a very complex law, and in the webinar today, I can only really talk about some of the most relevant parts and at a fairly low level of detail. While I have been doing this for a long time, I am not an attorney. I have done a lot of work and have my own opinions, but no one should construe anything that I'm providing today as legal advice. And I'm not sure I even introduced myself. So my name is Steve Metzer. I am the lead ADA specialist for DLZ Corporation. And as I noted, have been doing this work for well over 10 years in a number of states. And we have a very competent ADA team that we assemble based on each of our clients' needs for ADA investigations. So continuing on, the first item that we wanted to go over was some of the relevancy of this topic in the state of Ohio. And as you may or may not be aware, the state of Ohio through ODOT, as long as with a number of other state DOTs, are being required by local Federal Highway Administration offices to ensure that their local public agencies that they funnel money to uh, from Federal Highway are compliant with the ADA, which includes having a transition plan and self-evaluation and a number of other items like designating an ADA coordinator and providing that contact information, developing and publishing grievance procedures, um, and then performing public outreach during both the self-evaluation and transition plan phases. Uh, as you probably know, ADA has been around for a long, long time. It's coming up on its 30-year anniversary next year, and there's still a significant amount of non-compliance, not just in the Midwest, but throughout the country. I just got back last night from the ADA National Symposium in Dallas, and it's still amazing hearing the stories from both consultants and regulatory agencies from throughout the country, the small amount of compliance that's out there and how it is driven so much by lawsuits and legal efforts. So which is unfortunate. In the state of Ohio, the ODOT has not currently issued any firm mandate with milestones or deadlines for compliance. ODOT has been working very closely. Sarah Wade at ODOT, if you know Sarah, uh, has been working very closely with the um, Federal Highway Administration Ohio Division to try to avoid having to issue a mandate with specified dates and deadlines like some other states have done, hoping for voluntary compliance. But in discussions with ODOT, they do recognize that Federal Highway may pressure them to do that if they do not get voluntary compliance. A number of other states are working on voluntary compliance also. States of Missouri and Massachusetts are two that I'm aware of and have varying levels of compliance with that. But there are actually states that have issued firm mandates that basically have said if you do not have a compliant transition plan by this date, they will threaten to withhold federal funding, which for many communities can be millions and millions of dollars annually. The state of Indiana and the state of Tennessee are two that DLZ has done significant amount of ADA compliance work in, simply because of that mandate and the actions taken by those clients that have hired us to ensure that they are compliant with the ADA requirements and all of the mandates that are included in letters sent by their respective departments of transportation. As I mentioned, the ADA was first enacted in 1990 and really was the first legislation that was specifically out there to protect individuals with disabilities. Unlike the Civil Rights Act of 1964, it did not offer the protection for people with disabilities, but is considered civil rights law, and is not subject to a lot of the unfunded mandates and other federal legislation because it is civil rights law, and that's how many of the legal aspects and cases that come about through ADA are included, as well as some of the other supporting things like the Rehabilitation Act and some of the other um, uh, federal legislation that protects people with disabilities from discrimination. ADA has 5 parts or titles. We're going to be discussing primarily Title II, which is public services, which are those services provided by governmental entities. If you have more than 15 employees, you are also subject to Title I through the Equal Opportunity Employment Commission, or EEOC. And if you are a private business, you're subject to Title III, which is public accommodations, which are all the different categories of private businesses that provide goods and services. Looking through the ADA very briefly and how it applies to local units of government, you recall that I mentioned that Title II refers to local government entities, and it is defined in the law as really any state or local government, which is essentially any governmental unit smaller than the federal government. And it also includes a number of different departments or agencies, as well as Amtrak. The Section 105 of the Title II regulations specifies the requirement for the self-evaluation, which was supposed to be completed by 1992. And you can see here a wide variety of local governmental agencies that DLZ has worked for in a number of different capacities. And there are many, many others that are specific to locations, states, maybe even sections within states. But you can see here that public schools and universities and park boards, library boards, transit agencies, some of them are their own public Title II entities. Others are departments of city or county government agencies, which is part of the scoping that we'll talk about here in just a little bit. The key aspect of Title II regulations in ADA is that no individual with a disability shall be discriminated against because of that disability. And this long paragraph here in Section 149 of the regulations essentially says that, paraphrased as I put it. So that's really the key thing here is ADA was intended to prevent discrimination from government services. The transition plan was required by July of 1992, which was 1 year after the self-evaluation was supposed to be complete. And as I pointed out a little bit earlier, we still see a very low percentage of Title II entities that actually have a transition plan, or there are a number of them that did do a transition plan when it was initially required back in the 1990s, but it has been essentially put on a shelf and nothing has been done to update it, even though the regulations have modified and updated significantly since that time. There are a number of other important components of ADA that we will not go into great detail about today. If you're interested, please contact me and I can get you more details and links to different locations. And the governmental websites that I will be giving you for reference at the end of the webinar today will also provide you with some of the information there. The figure that you see on your screen now is the very common one that you'll see at most presentations. If you've been to any presentations on the Americans with Disabilities Act previously, it really boils it down to the self-evaluation, transition plan, and community participation, particularly with the disability advocates and persons with disabilities in your community through that entire process to arrive at having a compliant transition plan at the end of your process. And we're going to first start talking about the self-evaluation. We respond to a number of requests for proposals or requests for qualifications throughout the country, as I pointed out earlier. And one of the really important aspects that we see doesn't always come through in those requests for proposals, or even with clients that contact us directly and are interested in having us assist them in some manner with performing a self-evaluation, is scoping. And scoping is extremely important because you need to identify what facilities do you own and operate or have programs in that need to be included. That could be everything from your city hall or your county municipal building to courthouse to your wastewater treatment plant and water treatment plants and a wide variety of other facilities. Once you've identified what facilities you have, what areas of those facilities need to be included as part of that self-evaluation? And we'll go into detail about all of these. Are there facilities that you run programs that you do not own? A good example of that would be polling. If you are a county agency that is responsible for elections and you have an election precinct in a church, you are certainly not obligated to ensure that that church is fully compliant, but the portions within which your voting program is operating within that church needs to be accessible. And we'll go into just a little bit of detail about that when we get to programs. And then obviously, lastly, is your policies and procedures, which are the what do you provide and how do you do it? Everything from bill pay to public meetings for your governmental boards and commissions to park and recreation programs. So it is extremely important that, as I mentioned, your self-evaluation is properly scoped. So let's start with what facilities need to be included. The facilities that are part of your program are really going to be dependent on whether you're a city, whether you're a county, whether you're a village, a town, a park and rec board, a library board, obviously all the different Title II entities. Generally speaking, we're going to lump them into a couple of different categories. The most significant of which are right-of-way facilities and non-right-of-way facilities, which are your buildings and parks, and then facilities that you might lease or have programs in, as we talked about a little bit earlier. So with the right-of-way facilities, that includes things like sidewalks, a very important program provided by cities. Some counties have a fairly good sidewalk program also, but primarily we see this with cities. Curb ramps, which are openings in the curb that allow people with disabilities, particularly those with wheelchairs, to get from the elevated sidewalk to street crossings. Pedestrian signals, transit stops and shelters, as I pointed out earlier. Many times transit agencies are their own Title II entity. In some cases, they are a department of a larger city. Number of cities like Chattanooga, Tennessee, the transit agency there is a city department. But if you get to others, like in the Lansing, Michigan area where I am at, the Capital Area Transportation Authority is their own Title II entity, and they provide transit services for the 3 or 4 county area surrounding Lansing. On-street parking is one that is often overlooked. I see a number of consultants that do plans or evaluations for clients and do not look at on-street parking. And street furnishings and other types of aspects, all of which are identified in the proposed accessibility guidelines put out by the U.S. Access Board in July of 2011. I will note that these are proposed guidelines and have not been formally adopted. There are actually no formal adopted right-of-way guidelines that currently exist, or standards that currently exist in the United States. And that's for a number of different reasons, but currently it's because of the non-regulatory atmosphere in Washington, D.C. through the Trump administration, which everyone is hoping will at some point loosen up and see the wisdom in having to do this so that the courts do not decide what regulations are pertinent and enforceable by the Department of Justice. So the types and amount of right-of-way facilities really does vary from community to community. It's really difficult to give you any significant um, aspect of, does a city always have more of this type of facility, because we see small cities in some areas that have a very high amount of sidewalk, and other areas we see large cities that have almost no public sidewalks. So it's really just depends on the location and the desires of the communities and elected officials in those. Once we get to our non-right-of-way facilities, again, we're talking about some very highly variable types, whether you're a city or a county or other type of local unit of government. The facilities that you own and operate or have programs in are very quite variable and can be everything from municipal buildings to police stations, polling places, libraries, water plants, public parking lots. Schools are sometimes part of the local government. Other times, schools are their own Title II entity, and it really depends. Once you get into some of the more interesting communities that have some very unusual facilities that we've evaluated, things like airports, whether it's a small community airport or something as large as an international airport that is owned by a city or a county entity, golf courses, convention centers. The city of Indianapolis owns the city Indianapolis Zoo. So there's really a wide variety of things that could be facilities within your organization. And for some examples, Johnson County, Indiana was a client that we did, and the unusual aspect of Johnson County, Indiana is, as a county, they not only had a county golf course that they owned, but they also had a significant amount of right-of-way facilities with sidewalk and curb ramps being right on the outskirts of Indianapolis. So it's very unusual when we evaluate a county for ADA compliance that there's a right-of-way component to the project that is nearly this large. However, when you get to a city, you can see cities have a number of different things, and Gatlinburg, Tennessee, if you're familiar with that area, is a very unusual and unique community, having a number of welcome centers, as well as a shuttle bus that they run people around the town throughout the day. So they have transit shelters, they have a public golf course, a very large convention center, and welcome centers that have a number of different programs, as well as the community center where they have a lot of programs that are put on by both their parks department as well as others. And then you get to a more rural county in Indiana, if you're familiar with Scott County, which is in southeastern Indiana. No right-of-way facilities at all, and really just a handful of facilities, most of which are fairly small, other than the county courthouse, which in Indiana, county courthouses are very large, turn of the century, 19th century in many cases. So there are some other aspects from a historical standpoint that we do need to look at. So as we move through the scoping, keep in mind that scoping includes also what areas of those facilities need to be included. So again, we've identified all of these facilities. We know what facilities need to be included, what areas within those, because obviously you don't need to do every office, every closet, every mechanical room or electrical room. So what does the ADA regulations and standards say is required? Well, first of all areas open to the public, even if the public is not regularly allowed, are required to be accessible. So that would include all of your public parking, all of your exterior sidewalks and exterior routes, all public entrances, all the circulatory hallways throughout all of your buildings that the public is allowed, obviously restrooms and drinking fountains and those types of things, but also conference rooms, meeting rooms, other areas where the public is allowed, even though, again, they may not be regularly allowed there. If the public is allowed through your employee entrance into a department, to a conference room, that's part of the public area. So that would need to be included in your assessment. In addition to those areas, we see what are identified and defined in the ADA regulations as employee common use areas. And these are essentially, in short, areas that are intended and utilized by more than one employee. And we've included some examples here with break rooms and kitchens and restrooms and locker rooms. And you can see below at the bottom in the boxes, the actual definitions right out of the standards and regulations that define what is a work area and what is not a work area, and defined as common use. It is important to note that employee work areas are not required to be accessible under Title II. However, under reasonable accommodation, if an employee is able to perform the functions of a job, what we call essential job functions, and you can accommodate them reasonably and easily to allow them to do so under Title I, those areas would need to be accessible on a case-by-case basis. And in its infinite wisdom, for once, the federal government did realize that you cannot possibly provide accommodations for every type of potential employee disability, and allows you through Title I to make work areas accessible on a case-by-case basis. When you're scoping those areas, trying to decide what needs to be included in your self-evaluation, floor plans can be helpful, but there are a number of limitations. Obviously, things change. The floor plans typically don't show furniture and other items that could change, clear spaces and whatnot that are required. So tread lightly. Through our experience, we've been able to rely on our past types of reviews we've done for other clients to generally know what percentage of a floor space, depending on the type of use and the number of employees in a facility, to allow us to determine what areas of the building and the percentage would need to be included in the self-evaluation. And for the most part, we've been fairly accurate. I've been burned only a couple of different times, and and that was usually in some of those Frankenstein buildings that it's a building and then it's an addition and then it's a wing and then it's another addition, and every time they do that they just continue to add more and more and more um, non-work areas that they identified that they really need. So but other than that, uh, just use your best guess. And again, if there's any question, we certainly urge clients, if they're doing their own self-evaluation, to evaluate the facility, evaluate all the spaces that they even have questions about, and then seek advice from others. DLZ has offered those services to many clients and suggested when they should and should not review certain areas of facilities with great success. So as we move on in the scoping, we'll talk about programs. Programs is another area that we see a number of clients, as well as some other consultants that only dibble and dabble in ADA compliance, really don't get a full understanding of what a program evaluation is. And that's because programs are quite complex and, again, really are highly variable depending on the types of government that you are, whether it's a county or a city or something different, as well as whether you're a very active type of government or much more passive, where everything is run through a small number of elected boards and commissions, and maybe even only through your city council or your county board. So programs can include a wide variety of things. So again, think of programs as, what services do you provide to your constituents, your taxpayers? It can be everything from, again, parks and recreation programs to courts to permitting, uh, public meetings, your police and fire and other safety, transportation, which includes both motorized and non-motorized, sidewalks and public works and all those types of things. So again, you can see here, this is not meant to be an all-inclusive list by any stretch, but it does at least, I think, hopefully demonstrate that the number of programs that each one of you on this webinar today may have is really quite variable depending on what you would have. And you would expect a city like the Columbus, Ohio, to certainly have a significantly more types of programs that they provide, simply because they're so much larger than a smaller town like Perrysburg or even Toledo. But there again, those metropolitan areas tend to provide a wide variety and a lot of different types of services as compared to a rural area. Websites are something that are very important, and again, are like the right-of-way standards, are something that have a best practice out there, but not something that's been adopted. So unfortunately, we're seeing throughout the country, primarily in Florida and California, where the appeals courts, the federal appeals courts, are setting precedent and essentially establishing website standards for the region within which they have jurisdiction. So we're very hopeful that that's going to change very quickly, but we're not quite sure of that. So, as I pointed out earlier, one thing about the differences between your policies and your programs and your procedures, the programs really are, what do you provide? And then as we move and start talking about the policies and procedures, those are really the, how do you provide those services and why do you provide those services? So those are a number of different things. And again, it really varies, even from department to department within the same community. The policies and procedures can be drastically different. And we've even seen where the personnel policy manuals, which commonly are one for each unit of government, we've seen where each department within some municipalities have their own policies and procedures printed for their employees, which differ, which really gets kind of crazy for us when we have to evaluate those as part of our self-evaluation of policies and procedures. As I talked earlier, there are a number of communities that do not own all the program or the facilities that they provide programs in. Again, voting is one that may be the most known, but parks and recreation, do you as a city or county parks and recreation department offer basketball programs or day camps at a local elementary school. You do not own or in any way have control of that elementary school and the accessibility of that facility, yet that's a program that you offer, and you're required to ensure accessibility to that program, even though you do not own that facility. So that's a very important thing to consider. Another one are public meetings. Quite oftentimes, your city commission or your county courthouse are able to accommodate a normal meeting of your governmental boards and commissions. But if you have a controversial rezoning or something like that, it's not unusual for those meetings to be moved to a larger facility to accommodate the anticipated uh, number of attendees. And quite oftentimes that's a high school auditorium or something else. So there again, that's your program, but it's in another Title II entity's facility. So it's important to ensure that when you schedule those types of things in facilities that you do not own, that you ensure that the accessibility meets your requirements, because it would be very difficult to uh, allow access into some of those areas that may not have access to someone in a wheelchair or other type of disability. The obligation for access to those types of facilities really falls on both the owner and you as the program sponsor, unless you have some type of an agreement. And that's a real detailed thing that we can talk about more in our on-site seminars that will be given in July. But we certainly recommend that you have your legal representation, your attorney review the language in leases. And we typically do recommend certain language in leases for both facilities that you rent out, like a picnic pavilion, as well as facilities that you utilize for your programs, like a park program, to ensure that it's very clearly stated who's responsible for what when it comes to accessibility. So again, the policies and procedures, some very simple things. If you get one thing out of today's webinar, it would be that there are a number of procedural aspects that you should take care of if you do not already have them. One of them, and probably the most important, would be to have someone in your community designated as the ADA coordinator. That person's name and contact information should be very obviously able to be seen on your website and any other types of printed or published information that you provide to your residents. ODOT and other state agencies that are looking to see if you are compliant with ADA will be looking for this very simply on your website, and it should be very easy to find. And we typically recommend that our clients, if they don't have it when we start working for them, that they do so after we have completed their plan, that they include an ADA information or civil rights or some other type of button on their main homepage on their website that they can put all of their ADA and Title VI information on. And here's a good example from the city of Maryville, Tennessee, one of our current clients that we are just wrapping up our transition plan for. They have a Title II ADA page, and on this page you can click a couple of different things to see both their Title II policy statement as well as their grievance procedure, and it has the name and contact information for their ADA coordinator. Very obvious, very easy to find, and we certainly recommend that each and every one of you today, if you do not already have this or have an ADA coordinator designated, you should certainly do so right away. As we're also looking at policies, procedures, employment. While employment is primarily a Title I issue, there are a number of policies and procedures that are part of our Title II evaluations, looking again, things that like personnel policy manuals to ensure that it discusses disability and the hiring, firing, and promotion of individuals with disabilities in the proper manner, ensuring that job descriptions don't discriminate. We recently had one client that included on every job description the requirement for a driver's license, even for positions that you would not be expected to drive as part of your work. Obviously, if you have a disability that would preclude you from getting a valid driver's license, you are automatically not eligible for jobs that you might otherwise be able to do. So they were in the process of reviewing that at our recommendation. We also look at applications for employment, announcements for jobs, essentially to ensure that there's nothing on there that would be discriminatory. And that's something that you would need to consider looking at. Many HR professionals have training or can get training to review the employment components of your policies and procedures. And if you choose to do your own plan in-house, that's probably the person that will be leading that. And quite oftentimes for that reason, we see HR directors or someone within the HR department be designated as the ADA coordinator. Although again, that we've seen it with public works directors and administrative assistants for city managers and a wide variety. There's really no one person or one job classification that we see designated more than any others. It's also important to ensure that in the provision of your programs, that your policies and procedures provide equally effective communication. That could be everything from providing an assistive listening system in your required assembly areas, like your city council chambers or other meeting rooms, ensuring that if someone wanted to have a sign language interpreter at a meeting so that they could participate and comment to the city council. Again, depending on what the aid is, you may need to have it readily available, or in most cases, you would have a name, phone number, or email address that someone can call within 2 or 3 or whatever number of days in advance of a meeting upon request. And then it's your obligation to provide that type of interpreter or other auxiliary aids and services to allow someone with a disability to participate in the governmental process. Ensuring that printed documents can be provided in alternative communication formats. This could be something as simple as a large print document. If someone with low vision requested meeting minutes from a recent city council meeting, they may need them in a large print format, and you can certainly do that with computer technology and printer technology today, whether you do it on larger paper or you do it with larger font and a larger number of sheets. But it could also include requests for people that have a hearing impairment to have things printed out, have meeting transcripts, someone with a vision impairment that would have things put in braille or any types of captioning that would be out there for hearing impaired. So wide variety of different things. Again, some of these things are case by case, but the important thing is to note that you need to be able to provide and have a source for providing alternate communication formats, and that's something that is typically readily available if you look for it and know where to look, and we provide that guidance and can assist any of you in that area as well. It's important to note that if you provide a service that has a fee or surcharge attached to it, you can charge that same fee or surcharge to someone with a disability. However, you cannot charge anything extra, nor can you charge a person with a disability the cost of providing accessibility through things like a sign language interpreter or other alternative formats. It's not something that we have really ever seen, but they put that into the regulations to ensure that if I requested a sign language interpreter and it was determined by your ADA coordinator that that was a accommodation that was necessary for me to participate, that you would not then come back and charge me. And that was really obviously done to ensure that I would not be afraid of asking for it, because quite oftentimes I may be a low income person as well as a disabled person, and that cost of that service to provide me the ability to participate may preclude me from asking. And that was really the key there. Do your design standards, ordinance, or details, construction details, have anything in it that is either inaccurate or violates the appropriate types of standards? Typically, we don't see that. However, the assurance that your plan reviewers and your field inspectors for things like streets and sidewalks and curb ramps, as well as your building inspectors, have a good understanding not only of what ADA requires, because ADA directly reflects building code, and actually the building code is a little bit more stringent with some of the updates because of the 9 years that it's been since the ADA building standards have been in place. But it's vital to ensure that the plans that are submitted and approved, as well as the as-built condition that your inspectors go out and inspect, um, the people that are doing those types of reviews have the proper training and knowledge and understand the importance of ensuring accessibility, as well as ensuring that everything is constructed according to the standards and guidelines that are appropriate. In addition to designating an ADA coordinator, one of the other very easy things for you to do tomorrow would be to go to the website that I'll give you at the end and get the example grievance procedure to formalize the process through which someone with a disability would file a formal complaint. Obviously, they do not need to file a formal complaint, assuming that if they were to call or email you or stop you at your office and had a complaint, that you could try to resolve it without going through the formal process, and we certainly recommend that if you're able to do so. However, there is a formal grievance procedure that needs to be adopted, and again, here is one for the city of Maryville, Tennessee. It goes through a very straight process of who you submit it to, what information is needed. We typically recommend our clients that they utilize a standard grievance form that goes with the grievance procedure so that you get the same required information for every complaint. And then there's a policy that goes through for both the time period within which you will make contact with the complainant, the time period allowed for investigations, as well as the appeal process that is that the complainant could go through if they were not happy with the resolution offered through multiple phases of the project. So again, this is something that's really easy to do, very simple to find examples. The Department of Justice has on their website a very good cookie cutter template that you can utilize and just insert your city, county name and contact information for ADA coordinators, and then modify as you see fit to meet your local climate of government. Public meetings are a very important component of the public process and governmental process in relations with the residents, whether it's a council meeting or a board or commission. Again, depending on what type of government entity you are, you may only have a small number of boards and commissions, maybe a zoning board and a planning commission. Other communities have a large number. I've seen some communities with as many as 20 or 30 different boards and commissions, and some of them may only meet once or twice a year. But again, they're all still public entities that the public has an opportunity to participate in every one of those meetings. It's important that you identify what public boards and commissions you have, when and where they meet, and ensure that the location where they meet is accessible. You know, you're not going to have a board that meets at the local coffee shop in secret, particularly if it's a location or a facility that is not accessible to the public. Those are public boards and they do need to meet, and typically they all meet in the same location, but they have different times and days that they do meet. As I pointed out a little bit earlier, most of those meeting locations do have a need for assistive listening devices, and I'm still surprised in 2019 the number of city council chambers, courtrooms, and other required assembly areas that are required to have assistive listening systems and devices available for the public that have hearing loss that do not have them. Providing copies of agendas and minutes in both readable format, as well as ensuring that they are able to be provided in alternative formats, as I talked about just a few minutes ago. If I have a vision impairment and you print out your minutes on the website in a scanned format and I have a screen reader, I'm not going to be able to utilize my computer to read that. So it's going to be very important to understand the need to ensure the accessibility for that. So also, do you broadcast either live or tape your city council or other meetings? If so, are they closed captioned for people with hearing impairments? We're starting to see a larger number of communities that want to increase participation by the public broadcast both live and tape versions of particularly their city council meetings. And many of them are utilizing services like YouTube, which will close caption both live and later, and other technologies. So that's something to consider that many communities do not even think about, and they just plunge right in and broadcast their meetings without realizing the potential discrimination that they have against people at their homes with hearing impairments. Do you have emergency procedures in place for evacuation, or your community-wide emergency management plan for evacuations of people with disabilities? And there are a number of excellent resources available on the internet, specifically related to people with disabilities and emergency evacuation or emergency preparedness. And I certainly urge you to get with your city and or county emergency management agency representatives to ensure that those are part of the process before it's too late. And we have all heard of some of the flooding and the evacuations that have been done for things like some of the really terrible hurricanes in recent years, and some of the unfortunate aspects with facilities like nursing homes that were not considered in evacuations. They didn't have enough vehicles to get them all out of the harm's way, and some of the repercussions and some of the tragedy that happened there. So planning ahead is certainly important, and to ensure that things like emergency shelters are able to accommodate service animals, and some of the things, again, that um, I see a number of emergency management plans annually that are very cookie cutter and really do not go into the detail needed to consider people with disabilities in a number of the emergency procedures. Public information. Every one of your public meeting agendas should have a statement on there about your community's desire to provide equal access to all city programs and facilities, and who they need to contact and when they need to contact them in advance if they need special accommodations to participate in a program or a meeting. This is something that I still see very, very low compliance with. Um, and again, it's something that's very easy to do. If I, as a person with a disability, see a public meeting agenda either in the newspaper or at City Hall or elsewhere, get a wind of it through a newspaper article, but I have a speech impediment or a hearing loss that would require American Sign Language interpretation or other accommodations. If I call, I need to be able to know who to call to let you know that I want to come to the meeting on Monday, and I need a sign language interpreter to assist me in communicating with your city council. And if there's no statement anywhere on your website or on your agenda to let me know who to call and when I need to do it, um, it's going to be very difficult to accommodate. And uh, I've talked to this client a couple of different times. This is their original statement that they drafted, and have convinced them that 48 hours is not nearly enough time to get accommodation. We've now changed it to 3 business days, because consider if your meeting's on Monday, 48 hours falls on a Saturday, and if they send an email, you're not following your own policies. So it's important to consider all those little things. Again, that's where experience was really, really helpful. So things like equal opportunity postings for jobs, the non-discrimination notice for meetings at the bottom of the slide, signage, whether it's directional signage or informational signage in all of your buildings, and a wide variety of other aspects of public information for your programs, policies, and procedures. So again, it's important that all communities educate their staff on ADA issues and ensure that staff that needs training gets that training. And we almost always recommend specialized training for your ADA coordinators, law enforcement officers, parks and recreation staff, staff within your community that have a high amount of contact and interaction with the public. It's very important, even if it's just something as simple as disability etiquette. You heard me discuss a little bit earlier about the importance of having plan reviewers and inspectors understand the importance of ADA, and getting them specialized training on what the requirements of the standards are and what to look for and some of the most common errors. Um, ensuring that your operators are able to accept calls through a relay service and other types of things. So again, can't go into a great amount of detail, and we'll continue to move on. But one of the other components that's required at both the self-evaluation as well as the next topic, the transition plan that we'll talk about, is public outreach. And there are a number of disability organizations that will assist you not only with training free of charge or for a fairly small fee, but will also assist you with identifying barriers, with telling you what their constituency sees as barriers to your services, programs, and policies in your community, if you just reach out to them. So it's really vital to try to reach out. Unfortunately, in our experience over 10 years, we find that public meetings and other outreach we do to even disability advocacy groups gets very, very little response because it's not a controversial subject. It's just one that they are used to not being taken seriously by many elected officials. So the best thing you can do is at least do your due diligence with reaching out. At a minimum, we recommend publishing a notice in the newspaper that you're doing a self-evaluation and transition plan. We sometimes like to develop a list of advocacy groups in the community and send a letter out, and those advocacy groups could be national, like the ADA Center. There are 10 or 11 ADA centers throughout the country that handle anywhere from 3 or 4 up to 6 or 7 states, as well as some of the other agencies. And this is just an example for one of our clients in Tennessee that we sent letters to. The letter is very simple. So it just basically says that such and such government is conducting a self-evaluation, and we would like to hear of any facilities or programs that you or your uh, uh, advocates and your constituents may have as either a barrier or a perceived barrier. We've since moved a little bit away from this and gotten onto use of online surveys. If you use an online survey, it's important to not only publish it on your website, but also advertise as many different places as you can, particularly if you can get a press release to let people know where they can get to the um, survey and just to let them know that it's there. You'd be surprised at how many people uh, do not see the online survey and during the comment period for the transition plan want to provide more comments when they could have done so at a point in the process when we could have actually utilized that in formulating our transition plan. But it's just a very simple thing that we provide through Constant Contact, which is how you register for this webinar, and just ask them a number of questions, and does provide full anonymity. And it does tend to lead to a number of good a number of good comments. In the city of Maryville, we ended up getting 26 people responded over the period of a couple of weeks. So, I did mention public meetings tend to get very, very little interest. If you do get a number of people that request a public meeting or call you or email you, and it appears as though there is interest in having a formal get together or a public meeting, that can certainly be a consideration. But I can tell you from personal experience, I have scheduled and sat in more than one meeting room for 2 hours, and the only people that showed up were my staff and my clients. So based on that, we continue to try to tailor and figure out new ways to increase our outreach efficiency and effectiveness. And I'm certainly open if anyone has any suggestions. You know your community better than anyone else. So when we go into a client's community, we ask them how do they normally have the highest success rate at getting people to come to meetings. And quite oftentimes we hear the same thing, that if it's not a controversial subject, they get very, very low participation. But this is something that we continue to try to work on, and you are obligated to at least try. And I think that's the key thing, is demonstrate what you have done, what things you tried, what works and what doesn't work, and be able to justify that if questioned by someone with authority. So again, in performing that self-evaluation, there's a number of different options. We've seen staff from communities that have done it. Consultants like DLZ have done that full service for our clients. Sometimes we get volunteers, although I would almost caution you against volunteers, because sometimes you get what you pay for. But oftentimes, it's sometimes a combination. We have successfully assisted a number of communities with both full service as well as coming in and doing 2 or 3 days of training in the field for right-of-way and non-right-of-way facilities, and then they've gone off and done their own thing and had fairly good success. Obviously, that all depends on the availability of staff. And quite oftentimes during the summer when most of your right-of-way facilities need to be evaluated, especially if you're in an area where that gets snowfall, you cannot evaluate right-of-way facilities with snow. So um, it's very difficult sometimes during the summer with construction projects and everything to provide staff. But we've even had good success with college interns and are assisting some clients, including a couple in Ohio that will be utilizing interns with data collection in the right-of-way. If you do decide to do some or all of the self-evaluation yourself, it's important to have a good checklist and know what each facility needs to be evaluated. There are some checklists that are readily available. If you were to go online and do a search for ADA checklists, this is probably the one you're going to get, which is one that was published by the ADA National Network and based on the 2010 ADA standards for accessible design. I would, however, caution you to have a very good understanding of not only the technical provisions, but also the scoping provisions we talked about scoping of what needs to be accessible. And it's very important to know within the standards what needs to be accessible as well. And that's one of the limitations on some of these types of checklists, because you need to develop an eye and an understanding of, if I go into a community center, or if I go into a rec center, what can I expect to find there and what do I need to evaluate as part of that? Recognizing that shortcoming, DLZ has worked over the last 10 years since we started this process to develop some of our own data forms, and have about 2 years ago converted entirely to electronic. So we have data forms for a variety of different things like sidewalks or restrooms, um, courtrooms, a wide variety of different things that you would evaluate if you were in a different facility, and put those on iPads with Excel and are able to go through very easily. And we have made these available to clients that have hired us to do training, and would be able to offer the same thing to anyone that would desire to get these as well. There's nothing secret on here. It's just we've put it in a format that we like and works very well for us, and continue to modify and adapt those as time requires. So moving along here, as we're right at the 2 o'clock hour and getting on the limits of where we wanted to have our presentation and open up the questions. But if you decide to perform your own self-evaluation, it's important to have the right types of tools. At a minimum, you need a SMART level. It's much easier to use a SMART level than it is a level and a tape measure and do your trigonometry, unless that's something that you really are interested in. You'll need some type of a measuring tape, and then obviously all these other tools here. We will make this presentation available in PDF form, and anyone that wants it can contact us, and we will send you a copy of this if there is information on here that you would like to get. I would also certainly urge you, if you do decide to do your self-evaluation with either city staff, interns, or other volunteers, please ensure that safety is the most important component of this. You're going to be working, particularly if you're doing curb ramps and sidewalks, in areas that are frequented by vehicles. And the last thing we want, or anyone wants, is for someone to get hurt. So ensure you wear your appropriate personal protective equipment. At a minimum, again, it'd be high visibility vests, and sometimes it's good, especially with entry level staff or interns, to double up so you can have two pairs of eyes watching for hazards while you're doing the data collection as well. That moves us to our transition plan, which I'll go over very quickly, because the transition plan is much more complicated and really a discussion much more appropriate for a longer discussion and seminar, similar to what we are going to be doing later. But if there's enough interest, we could put together an hour webinar later in the year just on the transition plan, if we get enough clients that are interested in preparing their own transition plan. The regulations really require 4 different parts of a transition plan at a minimum. It requires identification of the physical obstacles, which are basically all the facility and programs that we just talked about for the last 40 minutes. You need to describe in details how you will make those facilities accessible. And that's essentially your corrective action list that once you identify what is wrong, you need to identify what are you going to need to do to fix it, whether it's a renovation, an alteration, or or a remodel of a space, or moving to a new building. Third, you need to specify a schedule, and if that schedule is longer than a year, you need to outline how long it's going to take and how much you're going to spend every year and all those types of things. And that's really a phasing plan. And then lastly, indicate who is responsible for implementation of that plan. While your ADA coordinator is typically responsible for overall ADA uh, types of tasks, unless the ADA coordinator is someone who can adopt a budget, the official responsible is typically going to be the city manager or city council, board of public works, whoever can designate and budget money to make the necessary improvements to correct the deficiencies noted in your self-evaluation. You need some type of way of listing your non-compliant items. As I noted, all of our data collection is done in Excel, which allows us to take the data that we collect and put it into a new spreadsheet that includes an itemized cost for each item. We identify the guideline that is pertinent to each one of those, and we come up with a priority, which is based on how much that barrier presents uh, uh, or that non-compliant item presents a barrier to someone with a disability. Uh, for example, a paper towel dispenser that protrudes 8.5 inches when you're only allowed 4 at 48 inches, probably a fairly low priority. But once that protrusion starts to get out more, 8 or 9 or 10, and starts to get much higher around head level or face level, that starts to become a much higher priority because that's a safety issue that needs to be addressed. And we will typically provide even a general statement about short-term corrective actions for protruding objects. If you're not able to make those corrective actions immediately, at the very least, put something below it that is cane detectable to ensure that the immediate concern of safety and whatnot is addressed until you can actually move that to an area where it would no longer protrude. For your transition plan, you're going to have a draft plan that you make available for public review and comment. Once it has been reviewed and approved by by our client, you need to provide a notice of availability and where it's available. Typically, you're going to want to make sure that the public can review it at your administration building, whether it's the clerk's office, the planner's office, the city manager's office. Um, uh, you'll need to provide it somewhere that has extended hours beyond business, because many people do work the same hours that you have your building open. And if you only allow for public review of your document at your administration building from 9 to 5, it does not provide people that don't have access to a computer the ability to look at a hard copy. So we always recommend a local library or branch or some other facility that has extended hours. You place a copy of that for the public to review. And then your website, putting a PDF version that everyone can get to or can get to from the local library. Um, Allow for the deadlines for public comments. Is very important that you specify the public comment period just like you would with any other type of document, so people know that it's open from July 1 to July 15 and that they need to send them to this person um, by this date. Otherwise, they may not be considered. Um, Once your transition plan is completed and you take those public comments, then you're able to um, possibly even send that out to the same advocacy groups with a letter letting them know of the same items, that it's located at the clerk's office, the public library, and the township website. And again, notifying them of the deadline and who and how they can provide comments on that transition plan. So as an example, City of Greenfield, uh, 20,000 population in 2010, just east of Indianapolis. They had 14 different building facilities, 7 park facilities. They had a greenway that was several miles, but they also had a very significant right-of-way component for their programming. 126 miles of sidewalk and 400 intersections with curb ramps. That ended up being, I think, 600 and some curb ramps that we had to look at. So, very, very significant program. And just kind of got to give you an example. This community, the priorities in the transition plans that we would develop itemize everything by the type of facility as well as by priority. And you can see that the total program for ADA compliance for this 20,000 population town was 7 million. And if you can imagine, their annual general fund budget is about 7 million. So this is going to be a long-term process. I would note that that only includes the actual cost, doesn't include soft costs or training or any other types of things that are really hard to put a budget on. But you can understand that it's a very significant thing. And I think every one of you that knows your community very well and the facilities you have and anything about ADA are quite oftentimes we see clients that know that they're very non-compliant and are almost afraid to do their transition plan simply because they are not able to do anything about it. I would certainly urge you to not be paralyzed by that and know that having a plan in place, even if you're spreading that $7 million out over 10 years or 20 years or 30 years, have a plan, because if the Department of Justice comes in through an audit or a complaint process, they will dictate what that schedule is and how much you will spend each year. And that I have seen many communities just really struggle economically to make that happen. So having a plan is certainly much better. Don't be overwhelmed. There are a number of easy items in your highest use facilities that should be done first. Obviously, things like getting into buildings, having restrooms in buildings are very, very important. But you need to be able to get into the buildings, especially the high use facilities. It doesn't do any good if everything inside the building is good if someone in a wheelchair can't get in because they have to traverse steps to get into every door. So again, look at what you have, figure out the easy things, that low hanging fruit. Focus on parking, your accessible routes, your public entrances and restrooms, and then move on to some of the other bigger ticket items. And that allows you to look at master planning, maybe some other renovations that might be needed that you've been trying to do and considering. It allows you to develop maybe even a capital improvement plan for your building facilities and identify efficiencies that can be accomplished as you move through that process of not only improving your accessibility, but maybe even improving efficiency of your buildings, closing some older buildings that may need a new roof, or even selling it to someone else to raise revenue. We've seen that happen many, many times. You may not end up spending equal amounts annually, and I would hazard a guess to say you will probably almost never do so, particularly if there are economies of scale. If you have a large building and you have 10 sets of restrooms that need to be done, it may be cheaper in the long run to have all the plumbing work done at the same time. And you may need to do it that way anyways, just to update to current plumbing code. So again, case-by-case basis, transition planning is very, very difficult, and something that you really need to look at, not in a vacuum. And again, don't forget to look at those procedures. Many times there are some procedures that can be altered that will avoid entirely some renovation and other construction projects that would be needed to improve accessibility. You may have a number of boards and commissions that meet all over the place, and only one or two of the meeting rooms that you utilize are accessible. Well, rather than renovating all of those meeting rooms, it may be easier to modify your schedule of those boards and commissions to meet in the rooms that are accessible, rather than spending money to renovate those other spaces that are rarely used and are only utilized in a very rare occurrence and only for a very limited number of boards and commissions. So again, the key is to have a plan. I can't stress the importance enough of having a plan. Make it a good one. And there are a number of resources out there. Again, DLZ makes ourselves available to anyone who asks questions. If we can answer your question and assist you through your process, we are more than happy to do so. We would certainly love to work with and for each and every one of you, but we want to ensure that if you decide to move forward on your own, we are there to assist you with answering questions. We are a technical resource. I hand my business card out at a number of different places and urge people to call me if you have a question. Obviously, if it's going to take me 3 or 4 days to do something, I can't design things or have our architects design things for you, but I can certainly look at pictures and respond to emails and other questions fairly easily and quickly with the experience I have and some of the different things I've seen and talked to. Some resources. If you have not been to the ada.gov website, which is the U.S. Department of Justice website, I certainly recommend that you get on there, become familiar with it. This is where you can get copies of the ADA standards. You can see some of the enforcement actions and things that they look for when they come into a community. Sometimes they only look at small areas of communities, but they also have done entire communities, cities, states all throughout the country. The city of Toledo, I think, was the very first one in the country that was done under their Project Civic Access. So a lot of good information on here. They even have under technical assistance materials under Title II, guidance for small towns and cities, and other Title II guidance that is very specific. So again, this is a great website. It's one that I go to all the time. And they also do have a technical assistance email as well as a 800 number that you can call if you have questions. They are more than happy to provide you with that technical guidance and respond to questions. Um, they, I get questioned all the time from clients. Well, if I call them or send them an email, they're gonna put me on their list of somebody that's, and that is not the case at all. The technical assistant staff that enters and answers those phone calls and emails are there to assist you and to provide technical assistance and guidance as well as interpretation of the law and design standards. So uh, do not be afraid of that. And if necessary, send me the question and I'll forward it on anonymously to them like I have done for a number of other clients, and just verify what I would tell you anyways. The other source of great information is the U.S. Access Board. The U.S. Access Board is an independent federal agency that goes through and develops most of these guidelines and standards that we utilize. Uh, the public right-of-way guidelines in particular, you can see at the top, the guidelines and standards button there. The Access Board is comprised not only of staff, but is also of people with various disabilities that go through a number of different studies and other activities to try to identify how facility access can be gained for all the different types of disabilities. Don't think of disability strictly as someone that's blind or someone that has a mobility impairment or anything else. There's a significant number of different types of disabilities, and each one needs to be accommodated differently. And the Access Board is a great source for that. They also have some technical assistance. So that brings us to the end of our presentation right at 2:15. So we do have another 15 minutes. As I pointed out at the beginning, if you want more detailed information, please do not hesitate to contact DLZ. My contact information is there. Um, you can contact anyone at DLZ that you know, and they can get you my contact information. If you're not able to get it, we will make this PowerPoint available in a PDF format and can send it out if you would like it. And we would certainly encourage anyone that would like much more detailed information to consider attending one of our seminars in our Columbus, Ohio offices in late July, and there will be more information forthcoming on that with invitations. So with that, I would open it up to questions or comments on the chat room. I'm not seeing any questions come up on either the Q&A page or on the chat room. So I either did a really good job, everyone fell asleep, or everyone's getting off. So at this point, again, I would certainly offer my email and contact information that is on this slide if you would like more information. And again, thank you from all of us here at DLZ for allowing us to serve you in one way, shape, or form. We look forward to seeing you in our Columbus office or in other fashion. And again, if you have any questions about today's presentation or the ADA, please do not hesitate to contact me via email, and I will respond as promptly as I can. So again, thank you, and I wish everyone luck in their ADA compliance endeavors. Thanks.